Thank you very much, Inhan and Yulia, for inviting me and having this great opportunity to present my research, which is a huge project now led by Professor Lionel Bentley. And this research is related to that project, and I combined some of the recent case law in Europe with this project and presented here. And it's still under work, so it's open for discussion. So this is a picture. If you tell me that you see a hand and some eggs, I would say I see personality rights and copyright. As you see, if let's suppose this hand is a person like you or me, and I put it onto my blog, Facebook, saying that somebody, Mr. Shakespeare, has taken some drugs in a private party, and this is his crazy image. So you're going to be angry, and that's the personality right. And the X, let's suppose it's your poems or whatever, your articles, and I just uploaded them onto my blog without your permission. And actually you wanted to put those poems into a collection to make some money. And now you claim that I infringed your copyright. So we see that personality right, or privacy rights as we call it, is actually your right to control your own image or your likeness or your private life, and not to be interfered by the others. So sometimes it's been divided into the right to publicity, which is called in the States, and the right to privacy under some human rights conventions. And copyright, as we know, is also a human right actually, but sometimes we tend to forget it because copyright law is so strong. And but it still means that you have the right to get remuneration for what you have worked, and if you are the author or performer or an actor. But both rights are not absolute. We know that we can speak freely is protected by law itself, so that we can get information from somewhere, and we can give information away for some others. So freedom of expression is a widely protected human right and constitutional right, but it's also subject to the control of some others, like copyright or personality right, or sometimes we say public order or public interest. So in order for these kinds of rights to come into conflict, we have to note that there are some conditions. First, we have to see that they are actually engaged, that freedom of expression is really engaged in a copyright case, a copyright infringement case, or a violation of personality. And second, that copyright is really infringed under copyright law, or privacy is violated under privacy law. And third, the copyright law or personality law or privacy law does not provide sufficient protection to your speech. So these are the preconditions. And how do the courts around the world generally decide on the potential conflicts between these rights? It's the famous three-step test. Under, for example, the ICCPR, it's prescribed by law. It must have a legitimate purpose, like the rights for the protection of the rights of others. And it has to sustain the so-called necessity test or proportionality test. So we do see around the world a number of cases over the history. In the United States, we know that there is a First Amendment. It's called First Amendment because it's very strong. And so in many cases, freedom of speech really takes priority. So there are courts around the world have decided over many cases on the potential conflicts between freedom of expression and copyright. In the States, some courts say copyright is not antithetical to to freedom of expression, because it's freedom of speech is always takes the first place, and copyright has to be interpreted in a way that lives up to these standards. And in Europe, we found that some courts say copyright is really antithetical to freedom of expression, but copyright has, there is a kind of hierarchy there, so copyright may be somewhat lower than freedom of speech. And if we take a look at the recent internet cases, we will see that similar remarks have been made by the European courts. And earlier this year, there are two cases quite famous. It's Ashby Donut versus France, and the other case about it's the so-called Pirate Bay. So the European courts have made the remark that generally there might be a tension between copyright and freedom of expression. So wherever you say somebody infringed your copyright, you may say this is generally a kind of conflict or interference with your freedom of speech. So likewise, there are also many cases, and over the history there are actually a number of cases about the potential conflicts between privacy, personality rights, and freedom of expression. And we see that almost all the EU member states have been involved in a certain way in such kinds of cases. The major point in these cases is that there must be, this is personality, not copyright. There must be a balance between personality rights and freedom of expression. Okay. So till now, I would say this is a global conundrum, and I don't want to open that Pandora's box here today. What I have said above is just to show that there is generally a potential tension between freedom of expression and some other kinds of rights, which I would call information rights. Because in internet cases, you often came across a kind of act to give and seek information, and on the other hand, somebody that controls such information. So these information rights have to be balanced against freedom of expression in internet cases. And here is an example about a trade agreement which has also incorporated such kinds of fundamental principle of balancing different information-related rights. So what I want to make clear is that this kind of balance has to be taken into account, because whenever a court decides on the merits or the substantive issues, of course it takes into account those three-step tests. But what I want to say is this kind of balance between different information rights does not take place only in the final stage of the court proceedings, but it also takes place before the court proceeding even begins, or when you decided you are going to go to the court. So, for example, let's get back to the first picture. If that hand, the person, tells you that I'm going to sue you, so just take down that content on your blog, I think that's going to be a kind of deterrence or whatever, a chilling effect on your act of exercising freedom of expression. So whenever you decide to go to the court, there might be some kind of rules that do take effect on the way you look at your freedom of expression or your copyright. Recently there is a case, Pinckney, which I'm coming to in a minute. The plaintiff, Mr. Pinckney, who is a copyright owner, now claims that he's going to give up his copyright because he does not want to go abroad to face litigation, probably. So next I'm going to show you the jurisdictional approaches. The jurisdiction approaches in Europe, or maybe we should start from some other countries like the U.S. In the U.S., there is a dichotomy of jurisdictional approaches into the so-called personal jurisdiction and subject matter jurisdiction. Personal jurisdiction decides whether the court can hear over a case regarding a person who lives within the forum or outside the forum. And subject matter tells us about whether the court could decide over some kind of damages or certain subject matters or injunctive reliefs and so on. So in the UK, there's an ancient common law jurisdictional rule called forum non convenient. So it's, I don't know, this is a French pronunciation, it's called maybe forum's convenience. And in the United States, it's called the closest relationship. And in Germany, there is von Salvini had long established the rule of the seat of legal relationship. So in the EU, since 1970s, the Court of Justice of the European Union has long established a theory called connecting factors. So under that kind of factors, there must be some connecting points which help the court decide whether this is the best place to hear a dispute. So what I want to make clear is that in Europe, the jurisdictional approach can also be divided into two parts. We would not call it personal or subject matter jurisdiction, but rather I would say, on the one hand, it tells us how to identify a court, and second, whether a court can hear over certain subject matter, such as infringement or damages or injunctions. So in the EU, the basic rule of private international law, or in common law countries called conflict of law rules, are established in two basic documents. Jurisdictional rules are settled down in Brussels I regulation and Lugano Convention, which is similar. Applicable law rules are established in the Rome II Convention regulation. So we are just going to focus on jurisdiction, but we have to know that jurisdiction is very important because actually for copyright infringement cases or violation of personality, the applicable law, once a court has decided that will take the case, the applicable law would probably be the law in the local forum. So jurisdiction is quite important in that aspect. And let's take a look at the basic jurisdictional approach under the Brussels I and Lugano. Article 2 said a fundamental rule is to go to the place, the court, where the defendant is domiciled, where he is a resident, for example. And the other rule, which is supplementary, said in infringement cases or in tort or delict cases, you can go to the place where the harmful event has occurred or may occur. This is a complicated provision and has aroused a number of controversial discussions. So since the 1970s, the European Court has decided that under this provision there should be two understandings. The first is the place of the event giving rise to the damage, that is the place of the tort, where the tort was committed. And second, the place where the damage occurred. So my approach is to say that since freedom of expression versus other information rights are so important nowadays in the internet, shall we take a new look at the traditional approaches to prove whether these old approaches still live up to the standards of this fundamental principle of balancing? So my approach is like this. If we consider that what kind of effects these jurisdictional approaches are going to have on the defendant and the plaintiff respectively, that is the publisher and the right holder respectively, the publisher is going to have a choice even before he establishes himself as a newspaper or internet or newspaper news website. So he's going to have a choice of forum shopping. He's going to find out which city, which country is the best place for exercising freedom of expression, for example, in the States or in New York. And the right holder is going to have a look after he finds out that somebody is infringing his copyright or violating his personality rights. He will have the choice to go to a certain court for a proceeding. And then he's going to find out first which court is the best for him. So that may be, for example, in a defamation tort, London, because London is a very famous place for defamation tort. So nobody wants to go to the court, and facing litigation is a burden for both parties. So I think under that conventional approach, we may say that going to the court will bring you some kind of risk, like you're going to spend more money, or you're going to ruin your life even if you spend 5 years on a case. So that's going to be a burden. It's going to be a burden on the plaintiff who claims to have his copyright, defend his copyright or privacy. And it's definitely going to be a chilling effect on the defendant who wants to exercise his freedom of information. But if we really have to face a litigation, we would rather do it at home than to go abroad. So basically, it is a larger burden on that party which has to go abroad to face litigation than he does so at home. So the other party may have an advantage. So it's like this, that if we consider, the jurisdictional approach allows a party, like the defendant, to be sued at home, and this is the fundamental rule. So the copyright owner and the right holder of privacy or personality rights have to go to the place of the domicile of the defendant. Then the copyright owner or the privacy holder will have a larger burden, theoretically, because they have to go to abroad to sue that person. And on the contrary, if we allow the copyright owner or the right holder of the personality right to sue at home, the defendant, probably in an international jurisdiction, would have to go abroad then to face litigation, to defend his freedom of expression in a foreign country. So that's going to be another bigger chilling effect on the defendant. So what are we going to do? In Europe, this is done in 1990s by the European courts. They say, now we are going to give some kind of balance on these two parties. Although we find it is legitimate to allow one party to go to the other party's home, we find there is a kind of jurisdictional burden on either party. So what they did is to allow the courts to award different scope of damages for the infringement or for the harm. It's like this. Basically, under that case called Shevill, it's a personality right. It's a defamation case. It's about somebody, like a British citizen and several other British institutions who have been reported in a French newspaper doing something bad. And then they sued in England. And the French defendant, challenged jurisdiction. So the court said, basically, according to our earlier case law, the plaintiff should go to the defendant. This is a fundamental rule. But of course, where there is a damage, the plaintiff can also go to that place, wherever it is, to sue the defendant. The compensation that we give for having different jurisdictional burdens on either party is like this. If the plaintiff really goes to the defendant. He will have the advantage of being able to claim the full damages, that is, any damages that are incurred in all jurisdictions. On the other hand, if the plaintiff wants to go to, or if he chooses a certain place of damages, which is outside the home of defendant, he can go there and bring that action. But the defendant will face a bigger jurisdictional burden. So the defendant, once he wants to go there to face litigation, will get a discount. That is, the plaintiff can only claim limited damages at a later place. So basically, this is the Shevill principle. So there are two parts. One part, you identify the court, which is the best court to hear the case. On the other hand, that court may bring jurisdictional burden or risk on either party, and the jurisdictional rules will allow that party to have different scope of damages. So this is the fundamental rule in traditional media, as we call it, because at that time internet was not widely used. But this principle is was applicable to a number of other cases, such as IP infringement. And if we take a look at the internet cases, it's going to be different. Because if you upload something onto the internet, you can access it anywhere. So the place of damages become anywhere. Theoretically, the plaintiff can go anywhere under the Shevill principle to claim for damages. So this is going to be really a large burden for the defendant, because the defendant now says, look, the speech is really a terrible thing. I'm not going to exercise freedom of speech anymore because I'm going to be sued maybe one day in South Africa. And the plaintiff now has the choice of going to somewhere where he thinks maybe his personality rights or copyright or even some other kinds of rights, information rights like trademark, because trademark can also be a commercial speech. It means your product is very good. So what the European court did over the recent 3 or 4 years is that they have designed different approaches to solve this problem, still taking regard to the need to balance different information rights. The first approach is the so-called targeting approach. In the Sport Radar case, a German defendant uploaded some database data about the UK Football League, which is, of course, owned by some UK companies. And then the UK plaintiff went to the English courts and sued the German defendant. The German defendant, of course, challenged jurisdiction. And finally, the case was referred to the European Court of Justice. And then the court said, now, in this case, we have to note that the place of damages is that place of tort. If the place of damages is that place where the defendant has an intention to target somewhere when he uploads something. So if that act was infringing in the original place of tort, like in Germany, then this infringement can be regarded also as an infringement in England. So it's called targeting because you've got an intention to target somewhere. Originally, the targeting approach should be more a substantive law approach rather than a jurisdictional approach, because you have to decide first whether that was an infringement or not. But many cases, including the United States courts, have applied that approach widely, targeting. So in the US, it's called CARDA or CIPIL, certain famous cases. So if you go to the place of damages, you can only claim for the damages that have occurred within that territory. So, which is to say that Shevill, certain part of Shevill still applies. The only difference is that you have to identify a best place in internet jurisdiction rather than allowing the plaintiff to go anywhere. So this is the targeting approach. And there's another approach called edate Martinez, which is significantly different, because in that case, the court changed dramatically the Shevill principle by allowing the plaintiff to sue at home, but for the entire damages rather than limited damages. In that case, actually in that two cases, because these are two joint cases by the CJEU, and they were about one about defamation, the other about pictures, your photo. Photo was uploaded without permission. So in that case, what was notable was that in one of these two cases, the plaintiff claimed not for monetary damages, but for injunctions, purely injunctions. So in this case, the court said, of course, you can still go, the plaintiff can still go anywhere where the website is accessible. But if you really go to the place of the center of interests, which means, the court said, is where you live or where you work, then you can get an advantage. That is, you can claim for all the damages that have occurred in all the jurisdictions. So this is really interesting because it dramatically changed the Shevill, as we said, which said at the place of damages, you can only claim for limited damages. Now, this is important because the place of center of interests also fits into our concept of balance of different information rights. And so if you see here, the court certainly favors a little bit the protection of personality rights, because personality rights is a precious right. It doesn't make any sense if you allow the plaintiff to go to Africa, if you live in Europe, to claim for damages. So what he's really concerned about is the damages here at the place of the center of interests. Still another approach, the third approach, takes place in the Wintersteiger case, which is an Austrian reference. So in that case, it was about a trademark infringement. So we know that trademark infringement is a territorial thing, which means you can only claim for protection of your trademark if you have your trademark registered in that country. Otherwise, you cannot say, you cannot claim for damages. So in that case, what the court did was that the place of tort, as we have always explained, is now taking a new phase, because under the Shevill, it was not clear whether the place of tort is always the place of domicile, because in that case, the court said generally the place of tort, the place where you committed an infringement, generally happens to be the place of domicile, for example, for a newspaper. But the court didn't clarify whether it was always the case. If I happen to bring some document on my own, a defamatory article, and then I published it myself in another place, that would be different, right? In traditional media. So the implication under Shevill was that you can go to the place of the tort and claim for limited damages there. But in this case, in Wintersteiger, the court said, considering the factor of foreseeability, we should allow the defendant always, allow the plaintiff to to go to the place of domicile of the defendant. In that case, the domicile of an advertiser who uploaded a trademark onto his website. That place should also be the place of tort. So this is something new, because then for the party who wants to say he has freedom of expression, he's not going to have a choice of forum shopping. He will not say, okay, now I go anywhere. I choose a place where the trademark is not registered, and then I uploaded something. And you cannot go there, in fact, to claim for damages. So this is the implication of this case, that freedom of expression must take note of the other rights, because you cannot escape from this rule. So finally, I'm going to tell you about another case, which I think this case is somewhat artificially made. It's not a good case for information dispute. It's not about conflict between freedom of expression and copyright. But in this case, different kinds of internet jurisdiction rules have been made more clear. So that in this case, it was about someone called Mr. Pinckney. He's an English person, but living in France. So he's a songwriter. He composes songs. And one day he found his songs were pressed into CDs by an Austrian company. The Austrian company then somehow made these CDs available to two UK dealers. The two UK dealers were offering online to sell these CDs. So Mr. Pinckney went to the French court and said, and sued the Austrian company, not the two UK dealers. But he said, I wanted my damages back, without clearly specifying which kind of act was in question. Of course, he said the Austrian company reproduced my CDs. But as you see, in different colors, in white colors, these acts were actually identified by the court in the case. In green colors were some acts that were under discussion by the Advocate General to the Court of Justice of the European Union. So actually, it was about the fact. Under the fact, it was only an act of reproduction. And the French court asked about online distribution, because the French court asked the European court whether an act of online distribution can be pursued. So what I want to discuss is to divide the online copyright into these three different rights. First is the reproduction right. So according to the Advocate General, the right of reproduction should still be subject to the principle of territoriality. So it means if you reproduce someone else's copyright protected works, that's the place of tort, but the place of damages is also there, because whenever you reproduce, the damage is there. So it's the same place. And the second act is online distribution and making available. I combine them together because they will be dealt with in the same approach according to the AG. The AG discussed this issue and said that the damages should be claimed at two places. First, the place of domicile plus the place of tort. And this is the approach under Wintersteiger. So you can combine these two places into one and claim for entire damages. And the second part is the place of damage. So the AG suggested that the European court adopt the spot radar principle, that is, the targeting approach. But what I wanted to discuss here in green was not discussed by the AG nor by the European Court, but it was a proposal proposed by the Max Planck Institute, which provided a draft on the conflict of law rules for intellectual property. So in that proposal, the Max Planck scholars said there may be a possibility, even though intellectual property rights are generally subject to the principle of territoriality, the plaintiff can still claim for entire damages at the place of damage if there are certain conditions that can be met. One of the conditions is like this: if the damage is obviously takes place at the place of damage rather than at the place of domicile, which is to say, if we give an example, if I'm from Iraq and I upload Lionel's work in Iraq, in English, of course, and sorry, probably in Iraq your works were not that popular, so let's suppose. So there's a little substantial damage there, but in the UK, in Canada, in Australia, in many other countries, there are substantial damages. This means that under that proposal, Lionel can go to the English court and claim for all the damages. So this goes beyond the normal principle of territoriality. The only evidence that we can find currently under statutory law in the EU is the European Community Trademark Regulation and the European Community Design Regulation. So these two regulations explicitly allow the plaintiff to go to the place of damage to claim for all damages. So suppose in Wintersteiger, that trademark, of course, was only an Austrian trademark. If that trademark were a European trademark, it might be different. So this is a kind of discussion that we can draw from Pinckney. And finally, I want to refer to the court. The court in Pinckney decided on a certain act which the court did not specify. But the court said, of course, Pinckney can go to the French court because wherever the website was accessible, he could claim for damages. But strangely, the court didn't specify that act. And we know that the word copyright infringement is a quite universal thing. You must specify it before you can say there is a copyright infringement. Is it a reproduction right, or is it about online distribution or offline distribution or making available online? And what kind of right is in question? Is it a French copyright? Is it a French distribution right or what? But in that case, the court simply told us that we can apply the principle of mere accessibility. That is, wherever it is accessible, you can go to the court. So this is not a very clear case. Anyway, so my current conclusion is that in certain cases where you can go to, for example, in the Wintersteiger, the place of tort can be combined with the place of the domicile of defendant. Probably it protects the rights of the right holder of the personality right or copyright better, because the person who claims to defend his freedom of expression must take regard. But this is also a good thing for the person, because freedom of information and expression, he could still be sued at his home, and he has his home advantage. And the second conclusion is that different rights should be treated differently in the jurisdiction approaches. For example, if it is about a narrow territorial focus, which is to say, if it is about personality right, so you only have your interests at home, then you can claim at home, and full damages should be awarded. In that case, the right of personality could be better balanced against freedom of expression. And it is the case with trademark or copyright that they are widely protected. So probably most countries in the world protect copyright and trademark. So these rights are generally still subject to the principle of territoriality, and you can only claim for limited damages there. But in exceptional cases, maybe there might be a different conclusion. Okay, thank you.